Um, oh, great. Yes, please do record it. And Chris, maybe you can go just to yeah. So here today, right, you have Chris Bourne's my partner here in the Boston office, does a lot of, corporate stuff that's very relevant today. And I do IP and tech transactions. So both of us are kind of part of our emerging tech practice, helping, mentor, coach, and advise on hundreds and hundreds of startups all the time, right? We have a great platform to do that for. And a lot of times people think of attorneys as just using them for a legal task, right? Like, hey, if I have a trust or will or something, or a contractor, right? But we're actually trusted business advisors because we see so many different companies with different business model, different approaches, different issues, challenge, different successes. We're able to use that as give a lot of insight to the next generation of entrepreneurs. So we provide more than just legal advice per se. We give very grounded business advice that's tied into legal. And so Chris will be going over corporate stuff, and I'll go over IP. And I won't spend a lot of time on Foley, but you should know your audience. So Foley, we say AM Law 50 firm, which means we're one of the biggest top 50 largest law firms in the country, right? We've been around almost 2 centuries, over 185 years old. We've grown to 1,100 attorneys, 25 offices across the US. Chris and I are in the Boston office, and we literally do A to Z. Like, there's probably not a legal issues that we don't handle. There's a lot of things we do well, and the big areas we do really well is in our sector approach: innovative tech, healthcare, life sciences, manufacturing, energy, where we focus on multidisciplinary approach. And here, emerging technology, where Chris and I help companies get, formed, funded, grow, and sold, right? And that's a typical life cycle that we have a lot of experience in here. There's a lot of slide deck in here, type of things we do. I'm not going to go over that right now, but you'll get a copy of the slide deck, who we are, what we do. We have local presence, national platform, a lot of reach, and we have a very practical approach to these type of things. And today you're going to learn a little bit about that. And with that, I think we'll kick it off to just to be sensitive to time. I'll start with the advertisement for Foley, but more importantly, so you know who your audience is when we're speaking here. And again, we're going to break this in 2 sections, about half time each. Company formation, which Chris Bourne will take you through, and then I'll go through some IP considerations. Any questions before we start?
And Chris, how do you want them to ask questions? Do you want them to wait till the end, or should they ask as they go?
Either way works. So let's say both, right? And I guess, David, if they're putting in, they can raise their hand, and I'll try to, when Chris is speaking, I'll try to catch it, or you catch it, and then when we get to a point, we can stop. Or if there's something in the chat room and we catch it, then we're happy to address it. So this is, we have a formal presentation, but because of our close relationship, this is informal. So anyone has a question, no question is a bad question. You should ask them, because everyone's going to learn from it. So, don't be afraid to be interactive at any point during this presentation.
Awesome, thank you.
And Mr. Bourne, I think it's
alrighty
time to take over.
Happy to take over and run with this for a little bit, and then
real quick, thank you both for coming today, Mr. Bourne and Mr. McKenna. We appreciate both your time.
Absolutely happy to be here and happy to talk to everyone. And like Chris said, feel free to interrupt me at any time if you have any questions. I'll kind of run through the presentation, add in some tidbits of information from our experience, what we've seen with companies kind of at this stage, where there's some pitfalls to watch out for, areas where founders and startup leaders tend to run into issues and get frustrated with the process just because there is a lot going on. And, in many cases, this is always viewed as something that people look at as secondary to what they're actually doing, because you're looking at this, maybe from an engineering or a technology standpoint, and you have this great idea, this great product, this great technology, and all of your time and attention and drive is towards building that. This is the stuff in the background that, if it's done well and done right, it can stay in the background and you don't have to worry about it. But when it's done wrong, it becomes an issue that it takes your time and attention away from what you're really trying to grow and build. And that's where we come in, and that's where, we've seen these issues come up before. And what we're telling you is really in a way to prevent those issues from ever occurring, so you can just focus on what actually matters to the business. All right, so first up is always just the choice of entity. So, you're ready to start the business, you want to put an actual legal entity in place, and what is that going to look like? Is it a C corporation, an S corporation, an LLC? All of these are different legal entity types, and they have there's different reasons to do each of them. In many cases, startups are typically C corporations. This is if you're going to be looking for future financing from outside angel investors, venture capital investors, they're probably going to want you to be a Delaware C Corp. Maybe you start off with that. Maybe you want to be a little bit, easier on yourself up front and you don't want to go for the complexity of a C Corp and you go for an LLC. There are some benefits to an LLC. Those venture investors probably don't want you to be one, so they'll cause you to convert at a later point. But an LLC is a structure where you're still a separate legal entity, but it's limited liability to the members, the owners of it. And we call them members versus shareholders of a corporation, just given the legal structure. But, it's a little bit easier to run. Typically, corporations have a wide body of precedent and requirements under state law and under tax law that, corporations are a little bit more complex to manage. LLCs can be really straightforward, especially for a single member, maybe two people that are running a business. Whatever you say in the operating agreement is what goes. You basically have almost complete autonomy to manage the business as you see fit without any regulatory requirements or legal requirements to do things in a certain way. It's also helpful from a tax perspective because unlike a C corporation, which in the eyes of the IRS and the tax code is a separate legal entity that is taxed individually, and then anything that's distributed above it is then taxed again when it gets to the ultimate shareholder. An LLC is a pass-through for tax purposes, so it doesn't actually pay tax on the income it generates. It passes that on to its members for one layer of tax. It gets a little bit more efficient. Now, as you grow, as you get bigger, as you have outside investors, the LLC may become problematic because, like I said, those venture investors, maybe they have foreign entities and foreign enterprises that are invested that don't want to have US operating income, and they would rather have that blocked level where, they pay taxes at the corporation for all of that operating income, and they're only going to receive a return when they sell their shares at a later point. So for some investors, that's more helpful than to have that pass through. For an individual, having the single layer of tax may be beneficial, but it also, and then there's the other factor which comes into play, which is how are you taxed as an individual employee / founder? So if you are in an LLC and you're the founder, all of the income coming through that entity is going to be taxed on you as if you're earning the income. If it's in a corporation, you're going to have to be a W-2 employee of that corporation, pay, typical withholding on your income, and then anything else would be distributed and you'd get capital gains on that. On the LLC side, because you're a member, you can't be a W-2 employee. So everything that's coming through, if it's coming through on a yearly basis, that is just operating income you're paying taxes on. And if it's, if you're holding it within the company and then distributing it at a sale or at a later date, then you can potentially get the benefit of long-term capital gains. And just as a quick aside, capital gains treatment is at a much lower tax rate than ordinary income. So anything you get for working as an employee, that's ordinary income you're going to pay, it's the typical tax rates in the United States up to 39.6%. If it's capital gains, you're looking at about 21.5%. So a material difference depending on how these are structured. I'll also mention S Corps because these are also viewed as pass-through entities, but they do retain the corporate structure. The issue here, again, goes to what type of investors you're going to have, how many investors you're going to have, and how you want to structure the company. With an S Corp, you do need to make sure that you have no more than 100 shareholders. You can't have corporations or partnerships as shareholders. You can't have foreign investors as shareholders. It has to be US investors, individuals, trusts, estates, individual type investors, and no more than 100. Otherwise, you don't satisfy the requirements and you'd be treated as a C corporation with all the tax ramifications that come with that. We'll cover equity grants in a little bit. And then jurisdiction. Many founders just form in the state that they're located in. So, you can certainly form a corporation, LLC, S Corp in Massachusetts with the Secretary of the Commonwealth. You can go on and do a business search and see who the officers and directors are. All of that's readily available. However, if you're looking to scale the business, in most cases, we recommend doing a Delaware corporation or an LLC. And the reason for this is because, look, Delaware has less than 1/3 of 1% of the US population, but it's the legal home of more than 50% of all publicly traded companies, and 64% of the Fortune 500. The reason for this is because it has comprehensive corporate law, it's stable corporate law, and parties on both the investor side and the corporation entity side understand what's going to happen if there's ever a dispute. They have the Chancery Court, which is a court basically set up to manage disputes among businesses. And this is the most sophisticated business level court in the entire country for these types of disputes because it's the only thing they do.
Chris, we have a question.
Absolutely.
Yeah, I had a question. What do you have to do in order to be eligible to register it in Delaware? And can you change it later?
So you can change it later. That is, we re-domicile entities regularly. But ideally, if you're able to start from square one in the state that you want to be in, it just becomes easier because while it's not a difficult process, re-domiciling, it's just extra legal expense. It's extra time and effort that you're going to be focusing on something that you can just, start where you want to be and be there. If you've already formed a company and you need to re-domicile, that's easy to do, and you can do it at a later stage when investors require that you do so. In order to be eligible to be in Delaware, all you need to do is have a Delaware registered agent, which there's companies that are set up in Wilmington, Delaware to do exactly this. You pay them $500 a year and they serve as your local registered agent so that in the event that you get any, service of notice for a lawsuit or any legal documents related to the entity, they can provide that notice to this service provider in Delaware, and then they forward it on to you. The service itself costs $500. It's simple, and we do this. Every company has a Delaware agent, and very few of these companies actually have a physical presence in Delaware. You do not need to have the board of directors or an employee or a manager or an officer physically present in Delaware. We form these all the time from Boston, from San Francisco, from every other office across Foley. And most of these companies have no physical connection to Delaware other than the fact that that's where they're formed. All right, in terms of the mechanics to form these companies, so, obviously we have to figure out whether this is going to be an LLC or a corporation. If it's a corporation, then we incorporate it. If it's an LLC, then we form it. So you'll see things called certificates of formation, certificates of incorporation, articles of incorporation, just depends on what the jurisdiction is and what they call it, but it's all kind of the same thing. It's the legal document that actually creates the existence of a separate legal entity. Because without that, you are nothing more than either individually a sole proprietor, or possibly if you have multiple people working on the same endeavor, then you would be a partnership under state law, but you don't have the benefit of actually having a registered specific type of entity that you've chosen and set up a structure around. Once you actually form the entity, you need to figure out, all right, how is it going to be managed? Is it just you? Is it going to be you in a group? Is it going to be, for a corporation, you're going to have a separate board of directors and separate officers? And I'll get into the details of that in a moment. You need to open a bank account. You need to actually issue equity in the business. Is it stock for a corporation? Is it membership interests or units of an LLC? You have to think about things like, all right, what about payroll, insurance, tax withholding? All of these things, as the business grows, you start hiring employees, you start operating. Are you making sure that you're monitoring all of these obligations of a company while you're also growing the business and doing whatever it is that you're actually focused on doing? Creating that technology, developing the new product, all of those things are your number one focus, but you still need to make sure that you're doing the appropriate administrative things for the company. So, depending on where you're operating, you may need a license from the city where you physically reside and have the business. You need to make sure, by all means, you must make sure that if you have income, you're paying taxes appropriately at the state and federal level. So for corporations, this is typically due on March 15th every year, as well as for April 15th, and then 3/15 for S corps and partnerships for pass-through entities. In the state that you're formed, you need to do likely some sort of filing in Delaware. It's an annual report. Fun fact for Delaware, everyone, when they're forming these companies, oftentimes they say, well, I'm going to be the only shareholder of the company, and I just want, because it sounds cool, I'm going to issue myself 100 million shares of this company. There is no difference between having 100 million shares and having 1,000 shares of the company, except when you fill out your Delaware annual franchise tax report, which is calculated based on the number of issued and outstanding shares. So by giving yourself that huge number of 100 million shares issued to yourself versus issuing 100 or 1,000, you've just exponentially increased your tax bill on a yearly basis for no reason whatsoever. Base the number of shares on the number of shareholders you expect to have and the ratios among those shareholders. You can always issue more, you can always recapitalize the company if you need to. But if it's you and 3 other people, maybe you only need 100 shares and everyone gets 25. Or maybe each person gets 10 and you leave 50 unissued, so you can issue incentive equity and options and other type of equity in the future, and you're saving yourself, and then you're paying that minimum tax in Delaware rather than inflating the amount you're paying the state every year for no reason whatsoever, other than 100 million shares sounds cool. All right, so ownership of a corporation, again, this goes to the stockholders. So these are the owners of the company, and note that, like I said before, if it's just you and a couple people, maybe that's a partnership under state law, but it's not formal. When you form a corporation, you need to actually issue the stock, because the corporation as a separate legal entity is not active until you've actually issued those shares. So it's not just file the document in Delaware and walk away and you're done with it. You need to actually go through the remaining steps and issue those shares. The stockholder does not actually manage the corporation, as opposed to an LLC where the members can be the managers. The stockholders appoint the board of directors. The board of directors will then appoint the officers who manage the day-to-day of the company. So the board of directors, they kind of generally align the business and affairs of the company. They appoint, you have to appoint the board. It can be one individual, it can be a number of individuals. Another thing we always say is make sure it's an odd number of people, or at least the voting ascribed to the board is odd, because if you have an even number of directors, you're setting yourself up for discord and stalemate, because if you have 2 on one side, 2 on the other, you're never going to be able to get anything done, especially if you have the same type of shareholder arrangement where, let's say you have 4 people form a corporation, everyone gets 25%. If you have the board that is controlled by the shareholders, again, anything that is even is often going to be a 50-50 dead heat, and that just creates more problems. But again, board members, it can be a single person that is the sole board member. And in their capacity as the board member, they still make these decisions. And generally, directors, the board of directors, any board member, they are subject to fiduciary duties to act in good faith in the best interest of the shareholders. So that becomes very easy when it's a sole shareholder and they are the only person involved. They're the director, they're the officer, they're the shareholder. But when you have a much broader group of shareholders, this becomes a very important thing you have to consider as a board member. Are you operating in the best interest of the shareholders and the company, or are you operating in your own self-interest, which is where you can get into trouble with fiduciary duties? The officers are all appointed by the board of directors. They manage the day-to-day. They are the president, the chief operating officer, the CEO, the people that are actually in the business, operating the business on a day-to-day basis. Again, for a very small early stage company, this could all be the same person or group of people. You can have one person be the sole shareholder, the sole officer, the sole director, and by officer, the president, treasurer, and secretary. They hold all titles, and it's just them. But as you grow, there's going to be different people for all of these roles. And again, you may be a board member and the CEO, or you may be a board member and the VP or secretary, but there's someone else that might be a president. Maybe you bring in a separate, experienced manager to be the CEO or COO of the company, even though you're still the founder and the chief technology officer, but you bring in someone to manage the day-to-day administrative operations. Other considerations at incorporation, this is where, what about issuing equity? So as founders, you own 100% of the business. You can own it just you, your group of 3 or 4 people. However, as you're looking to grow this business, what is the long-term goal of the business? Let's say 2, 3, 5 years down the road. Is everyone aligned that that's going to be your primary focus for the next 3 to 5 years? Is this something that you're doing now as part of your current program, and then you may go off and do something else? And is everyone aligned on what that's going to look like? Oftentimes what we do is we put vesting in place on this founder equity to make sure that people are actually sticking around and taking part in the business. Because what happens if 4 people get together, form a corporation, start working on it with the goal of in 5 years, they're going to sell it or transform it into this much larger venture. But one person decides, you know what, 6 months in, this is just not for them. This is not what they have their heart into, and they just want to go off and do something else. Or maybe they got an offer at a Fortune 100 company and they want to go work for a large corporation. That's fine, but without vesting, they still own a quarter of your company. So as you grow that, as you put in all this work and effort, they're getting the benefit of that without putting any effort and sweat equity into the business. So that's why with vesting, you can say, look, you're here at the beginning, you're part of the idea, but that equity is going to vest over a period of time. So for you to get the full benefit of it, you still need to be here either A, when we sell the company, or B, you get the full equity in 5 years, and you're going to get a component of that every, 3 months, 1 month, every year, whatever vesting schedule you set. Maybe it's you get over 4 years, you get 25% on every 1-year anniversary of the formation of the company. And then if they leave, they get whatever they've vested to date. So let's say that you have that 4-person group. One person decides to leave after 18 months. They've vested once after the first 12. They have 25% or maybe 20% if it's a 5-year vesting schedule. They have 20% of their equity that they've kept. The remaining 80% of their equity returns to the corporation, and everyone else gets the benefit of that growth. They get the benefit of what they produced in that first year.
Hey, Chris, there's a question. I think it's more the mechanics of it from Sandy. When do you do vesting? And do you put in job requirements too? So obviously, as you onboard an employee, there's something to do there, and how does it tie to their job?
Yep, absolutely. So when to do this is when you initially issue the equity. That's the ideal time. You can always put it in place later, and it just gets a little bit more complex. But ideally, if you can put all this into place when you issue the equity, that's the cleanest.
Chris, that usually comes like in a stock, what's it called? Stock purchase agreement or a stock agreement?
Yep, it can either be a stock purchase agreement, a subscription agreement. There's various terms for it, but it's basically the instrument, the legal document that issues the equity and says you are being issued equity for, maybe you're paying pennies per share based on the initial issuance, or maybe you're coming into the company 6 months in and you're buying it for, 50 cents a share, whatever it
If you're like an up and running company, you usually do it when the employee like onboards, right? The new person onboards. So obviously, if you've been a project and then you have people kind of forming a company, then you might do it at that point, even though they already kind of working with each other, right?
That's exactly right. So when you have it with someone that's entering an operating company that's already established, that's when you typically start getting into incentive equity, and we get into stock options and so forth, which I'll cover in just a minute. But what you'll do at that point is the type of vesting may be a little bit different. So for a founder that's starting the company or forming everything at once, maybe it's just time-based because, look, you all know that you're all fully involved and that's it. But for someone who's coming in, they want to make sure that they're actually going to contribute, and maybe it's performance-based. So there's going to set certain metrics in that vesting schedule. So maybe it's not just time-based. Maybe it's time and performance, where it must be a certain amount of time and there must be certain performance-based milestones. And that can be, if it's someone on the financial side, maybe it's financial metrics. If it's someone on the engineering side, maybe it's production or design of certain features of a product. You can set that based on whatever makes sense for the business, but you put it in place based on what that person is going to be doing. So that way they are tied to, and the success of their equity is tied to the success of whatever role they're playing for the company. Couple other things just to hit on quickly here. So you want to actually, name the company. That's going to be whatever the corporation name is. If you form a corporation with a name that isn't really right for the brand, you can always do a DBA, a doing business as, and you just register with the state and you say, all right, we're going to call the company Acme Inc., but we want to actually do business as the Facebook. You can still do business as another entity name as long as it's not used by a party in that jurisdiction. You just have to make a filing with the state so that way when you're going out to the public and portraying yourself as that, if there's ever an issue, the state knows that, all right, anyone doing business as the Facebook is actually Acme Inc., and then they have the officers and directors to go to if there's an issue. Intellectual property protection, I'll leave that to Chris entirely. If you're doing export, import, know that there's just a host of regulations, especially depending on what type of technology it is. That's a whole nother, session to talk about what type of risks there are. But basically, if you're exporting and importing something, make sure you're doing your due diligence and making sure that one, it's going to and coming from jurisdictions that you're legally allowed to do. Obviously, there are embargoes and you can't do business with certain countries like North Korea. And there's also types of products that there are tariffs and other restrictions on that you can't send. And then IP assignment, this is the one I'll mention just from an employment agreement standpoint. We want to make sure this is addressed in employment documentation or early stage documentation, even for the founders, so that whatever IP is developed for the entity is being protected. And I'll leave the rest of that for Chris.
Yeah, Chris, on that one, I always think of the company as a container, right? One reason to form a container is to put all your assets and liabilities together that you contribute. So on the IP side, you want that container to hold those IP assets.
Absolutely. The next big one, and this is where a lot of early stage companies get into issues, is employees or consultants. So they'll say, you know what, we're a small company. Everyone's going to be a consultant. There's no employees because we don't deal with the logistics of hiring employees, paying them a minimum wage, giving them benefits, tracking whether they're full-time, part-time, all of that. That's all well and good, but from a tax perspective, that doesn't matter. Because if they're operating as an employee and they're misclassified, not only would you still have to pay taxes and pay the requisite withholding and all of that as if they're an employee, but there's also restrictions and there's penalties that you would pay because of each employee you misclassify. So if you have, your CEO as a consultant, chances are that's a misclassification and you're going to run into issues when it comes to tax filing time. This goes for both federal, state, and local laws apply to this. The written employment agreement is not a requirement. You can still be a full-time employee with just a simple one-page offer, or even if you're just acting as an employee, even though you are, again, a consultant by title, you could still act in a manner that you don't have the requisite autonomy to, do your work and then do work for others that you would as a true consultant, and you would be reclassified as an employee. In terms of the value of equity to a startup. So again, this is where these things get into kind of a sticky situation because you may have a great idea, you have a great product, you're trying to scale that up and grow it and develop the product. So you have lots of equity to play with. You might have a valuation based on early stage investors and say you're worth $10 million, but cash is tight, you're pre-revenue, and you want to use stock as your currency to survive and grow. You can probably get some people to provide services to the company just for stock options or for the issuance of equity, knowing that they're going to get the benefit of that down the road, and they're willing to take that risk as well. However, this may never become a problem if it doesn't come up, but sometimes it does. And what happens when one of those people becomes frustrated, leaves, and then says, well, you never paid me minimum wage. And even though I held stock options or equity, I was never paid minimum wage. So I'm going to bring an employment lawsuit against the company that is going to completely sidetrack and refocus you on litigation instead of developing your company. This is not just, employees you bring in after the fact. This can even be one of the founders of the company can then turn around and sue the company for an employment claim because they were not paid a minimum wage. And I don't say this as a theoretical exercise. This happens on a regular basis. Founders get into fights, they disagree on things, one decides to walk away and feels like they're not getting the benefit of what they tried to grow, and they come back and turn around and sue the company that they formed with their colleagues, their classmates, their friends, and all of a sudden you have litigation on your hands from someone who may have been the CEO and decided, look, we don't have cash to pay people, so we're going to do everything with equity. And then they're the person suing the company, and it gets into a really sticky situation. Obviously, the other issue is dilution. When, if it's 4 people and you're all putting all of your effort into it, that's a pretty easy analysis to figure out how much everyone gets. But what happens when you're bringing in, we need an engineer for this specific role. We need to get someone in to run sales. We need someone for finance. And you're issuing equity in each of these cases. What happens when they leave? Do they still own a sizable percentage of your company? Especially if they weren't properly vested, or even if they were vested, is that amount of equity that they are entitled to commensurate with what they actually provided to the company? Back to the vesting, this is something where it gets into a tax issue as well. So when you're issuing equity, and there's really 2 types of equity you're going to see on a regular basis. And I'll grab that question after I cover this one, these 2 points. So equity versus options for an LLC, we treat it a little differently. In many cases in a corporation, you're going to see stock options. These options are going to be setting a strike price to say, look, the value of the company today is $1 per share. We're going to give you the ability to purchase equity at $1 per share at a future time, and this is your strike price. At the time that is issued, there's effectively no value because you have to pay $1 per share, which is what it's currently worth. So all they're giving you is the right to purchase something for the value that it is worth at that time. As it grows, you are going to then see accretion of value of the equity. The way to treat that from a tax perspective without doing anything else, and this is where we say this is where you want to stop and think about it, is without changing that. Let's say you have vesting over 4 years, every 1-year anniversary. If it's worth $1 a share now, all right, you pay 0 tax because that's what it's worth and you haven't actually, exercised that option. But what about in a year when you vest for 1/4 of that and it's now worth $2 a share? And then a year from then when it's gone up to $4 a share and you vest another quarter, and then $10 a share and then $20 a share. From the eyes of the IRS, without any other election, that is viewed as income when you vest in that equity at the then current fair market value. So all of that accretion and value, you're going to have to pay cash and actually pay tax and cash out of your pocket to the IRS based on something that you don't actually have the benefit of because you've never actually, you're not getting that equity, you're not selling it at that point. It's paper, it's value on paper that you don't actually get cash for. The way to avoid that is to file an 83B election with the IRS within 30 days of issuance. And that is the biggest point to focus on. It must be within 30 days. There's no way to remedy this. If you miss the 30-day window, there's no, you can't appeal to the IRS to get them to waive it and extend it. You have 30 days and that is it. But if you file within 30 days, the IRS says the value of this when you acquire it is worth, let's say $1 a share, and you're paying $1 a share for it. So that is 0 gain on the date of issuance. It can increase in value during that vesting period as much as it wants. You don't recognize the gain between $1 a share and $100 a share until you actually sell the equity. So when you sell the business, you get cash, and then you pay tax on the gain from that original dollar up to whatever it's worth at that time. That simple election, and it's literally a 1 or 2 page document that gets filed with the IRS, allows you to do that. If you miss it, you don't have that ability, and then you run into problems down the road. And with LLCs, this is where, some founders like LLCs better, because with that stock option, when you eventually sell it, you may still be paying. If you never exercise until a sale of the company, you're never going to actually hold equity in the company until that last moment. So when you sell that equity in a sale, you're not going to have long-term capital gains. You're going to have a short-term capital gain, which is taxed at ordinary income rates, again, up to 39.6%. If you exercise immediately for $1 a share, then you can get the long-term capital gains, but you have to come out of pocket. In an LLC, we often do incentive equity, which is going to be in the form of a profits interest. So you're issued equity on the date of the issuance. You may still have vesting, but you're issued equity based on the sale of the company and the value of the company at that point. So if you are going to have, let's say, an LLC that's worth $1 a share when you're issued it, and then it grows to $10 a share, you are going to share with the other members in the accretion of growth from $1 to $10. So, the dollar per share everyone else gets, you don't take part in that, but you take part in every dollar thereafter. And because of that, you actually own an equity interest in the LLC as of the date of issuance. So when you sell it, as long as it's 1 year or more later, you get long-term capital gains treatment. All right. And I'm just kind of getting back to the messages. I think it was.
Are you
Are you-
allowed to protect yourself from being sued in the stock purchase agreement in case of a disagreement between founders?
So you absolutely can. Oftentimes we set up a founders agreement or a stockholders agreement that sets up, a structure for a lot of the areas where we typically see disagreement, and you're pre-agreeing that if any of those things happen, this is how you're going to address it. Obviously, this is going to vary from company to company and from group to group, but you can absolutely pre-agree. Frankly, it's kind of like a prenuptial agreement for founders where you're agreeing, things go bad, this is how we're going to address it, and this is what we're going to do in that circumstance. Hopefully it never comes to that, but if it does, that's what it is.
Hey, Chris, on that one, just quick one. We can't protect against everything. Let's say employment law, you didn't pay minimum wage, right? You can't waive rights to breaking the law between each other, right? So there's still, it's not an absolute resolution to all your legal problems, but it's a strong one.
That's right. It's about the things where there's going to be an agreement that it could go in multiple directions. If you have a violation of law, that's a violation of law. You can't contract around, regulation passed by state legislatures, by the by Congress. Like you can't contract around that. You can contract around that and say, look, if one of the founders wants to leave, they have the right to be bought out at this price based on these metrics in the company, or they can accelerate their vesting in these circumstances. So there's a lot of autonomy of what you can agree to, but violation of law, fraud, the big things, you can't contract around that. And vesting only when you
Yeah, so
bring it.
Sandy has two questions. I think they're related, and Sandy can up one up here. I don't get it right. So vesting is only when you bring other people in though, right? Probably not.
Nope, you can
As
vest.
someone interested in coming on board with a vested interest, if she's a C Corp, can she ask them to invest financially in addition to meeting certain work requirements? Or is that not typical practice once you incorporate it?
So you can always ask someone to invest and actually put money in. The stock option route is typically to give employees the ability to seek equity without putting money in upfront, because they have that strike price. You could say, look, we're willing to issue you shares. There's still going to be founders type shares where there's vesting associated with them, but we're not going to issue them as options. We actually want you to purchase those shares for the then current fair market value. That's absolutely something you can do. It's not as typical, and we don't see it as often because in many cases, the people coming on don't have the capital based on the valuation of the company at that time to put cash in, and they're trying to put their work in as their contribution instead of cash, with the goal that they will have the ability to invest cash later.
And Chris, one thing, a lot of small companies will start off with the founder owns all the shares. And then later on, if you have investors, they may want the founders to go on a vesting schedule themselves, so they're invested in it, right? So even though you have all the shares now, that could change over time.
And venture capital and angel investors are absolutely going to ask early stage company founders to do exactly that, because they're the ones funding the growth of the company going forward.
Hey, Chris, I just have a quick question about safe versus convertible notes. Can founders still rely on those if they're trying to reduce or mitigate, diluting their equity down? What does that sort of look like if you're, going through an incubator, but your valuations aren't really set yet?
So oftentimes the safe is just the easiest option, and that's why, because you kind of avoid the valuation question a little bit. Convertible notes you still do as well because you're setting kind of an aspirational value based on what everyone thinks it's going to be. These are used all the time and really are a bridge to get from, when you're trying to avoid getting to that price round too early, you can use those and say, look, our aspirational value is X. We're going to give you a discount on that. And then it's just a negotiation between the investors who are willing to put in capital with that assumption and those that are looking for the capital.
Hey, Chris, just for sake of time, oh, perfect time. I would say that's
Yep, right there.
Guys, great questions. And since my buddy Chris here has the prompt and share, I'm going to be prompting along as we go along. We have about 20 minutes. I'll try to move fast, but obviously be interactive, and some pieces I might skip. So I always, when I'm in person in a group, I always ask all the early stage companies or projects, do you have IP? And a lot of people don't raise their hand, and I say everyone should raise their hand because everyone has IP, even if it's not registered. The reason is it's a little bit of misnomer in the sense that people think of intellectual property as a registered patent or trademark, things you register. But every company every day is generating some kind of intellectual property in terms of know-how, process methods, some technical specifications, designs, drawings, research, right? Business information. All of that can be one form of another of intellectual property. Some of it you may not formally protect, some you may protect. And my point here is to make what I call IP intentional. So knowing that everyone has intellectual property, you can take intent in terms of how you're going to protect it. And we'll talk about some of the tools there, like registered forms of patents and trademarks, copyrights as well. But all of these can go from intellectual property to registered intellectual property. But even if you don't have a registered, you still have intellectual property there, right? So if I ask that question, all of you should raise your hands if I ask that in the future. Next slide. So now we talk about the IP protection tools we have at hand, right? And we'll go through them quickly here. So patents, right? That's a way to protect your innovations, to exclude others from making, use, and offering for sale your protected subject matter technology, right? It is the more expensive form of protection because you essentially get a monopoly on the idea for 20 years. Next, you have copyrights. This is the right of authorship, right? Whatever work product you make that has a some creative contribution to it that you author, could be a white paper, could be software source code, a web page, all that could be copyrightable, right? And there is an official way to formally register that. A lot of companies don't do that on a regular basis, even my big software companies, just because it's expensive, but you still have some common law rights. And having it registered gives you some particular rights when you have to assert the patent through litigation. Trademark, that protects your branding, identifying the source of the good or service, right? So like a company name, a name of a product, a tagline, symbols or design symbols to identify a company. Those are ways to protect your brand. Trade secret. A lot of people leverage trade secret just by default is something that's confidential information, but has some business value that you take, some particular measures to protect, meaning you're not trying to have the whole world see and you treat it as a trade secret. And it can go on forever. And there's no particular mechanism to register it, right? So you have, all of you will have some form of trade secrets or not, even if you're not thinking about it. Then contracts. I always ask, what's the number one way? What's the number one way to protect your IP that everyone should be using all the time? Contractual. And we did talk about some of them already, right? In terms of even some of the employment agreements or founders agreements Chris Bourne was talking about. You want to make sure all the company IP is assigned to the company. May do non-disclosure agreements with third parties so they don't disclose the IP. And then when you license your product, you control your IP and how people can use it. So contracts is the number one way to protect your IP. So someone has a question about trademarks. When you trademark, does it stop another company from using your name? Yes, it can. It all depends. They may not in the absolute sense, but let's say you have a trademark and the trademark, the other companies use your name as protected by the trademark in the class or category of your trademark. Then you can use your rights there to kind of enforce it. And there's ways to go about doing that. And that's something you should look at. So the answer is yes, you can, generally speaking, without knowing the facts, if someone is actually doing, the zipper buddy versus zipper buddy, the "the" is not meaningful enough, right? They're basically, copying your brand name, and to the extent it's protected, you should be able to assert that. Next slide, please. Different types of IP can overlap, and I always use kind of software as an easily accessible example because we all use it every day. You could use all these tools to protect software, right? So, and you can't protect all of it with one tool in one specific way per se. That's why you may use different of those tools. So we'll talk about what patentability means, but let's say you have some functionality of software that's patent protected. You can protect that functionality. Your software does a whole bunch of different functions, but you can protect some of the innovative functions there. Copyright, works of authorships. You authored the source code, the object code, that's copyrightable, right? The next one was trademark. You have a brand name like Zipper Buddy for your product, and that's protecting the branding. Trade secrets, like the source code itself is a trade secret, like you're not gonna give that out, you're gonna protect that. Contracts, the software, you don't throw it out the door and give it a hand to the people, you have a license agreement to do that. So there, we just applied all the 5 tools to the same kind of product, right? Because it protects different aspects of that, and that gives a good example how they overlap. Trade secrets and patenting, those always become something that people think about. You can't do them on the same thing. The reason is that under patent policy, in order to give you that monopoly right, they'll say, hey, you have to further the sciences, right? And by disclosing how to make and use the invention. So by definition, you have to publish, right? Almost like an academic paper, not quite. So there you can't also keep it a trade secret. With copyright registration, there's certain parts of something you want to copyright that's not normally known to the public. You can block out the trade secrets of there. And be careful, is it really a trade secret? My reason I say that is a lot of folks will say, yeah, what's my IP strategy? I'm going to protect it by trade secret. Now they have a software platform, and the goal of software platforms is to make it ubiquitous. Well, can't they kind of figure out what the software is doing by it? So is it really a trade secret? The source code may be, but the functionality is probably not going to be. So be careful on relying trade secrets too much. Next slide, please. Patent versus trade secrets, right? So this kind of goes into some strategy is be careful with trade secrets in the sense that in order to infringe or misappropriate a trade secret, you have to have access to it, right? You had to breach some confidentiality or some access to it and misuse it, right? So if you have you're protecting some innovation by trade secret, that doesn't stop someone else from independently coming up with that same idea and using it. Because as long as they didn't access and misappropriate your trade secret, and they came up independent, they're fine to do that. Now with a patent, it's the opposite, right? They don't even have to know your patent exists or that you actually patented it. But if they actually build some product or technology or service that infringes that patent, regardless if they knew about it, they could be found infringing. So a lot of times we're figuring out trade secret strategy based on, do we think someone else will be A, doing this function, B, would we know they're doing it, right? And that's where we do some balance and act. So just to kind of give you some more insights on that choice there. Next slide. So here I'm going to give you some tech entrepreneurs' view of patentability. I'm going to give you sort of the legal standard and then the kind of entrepreneur lens that I apply to it, because a lot of entrepreneurs will ask the question, well, is it patentable? Frankly, unless you're a patent attorney, you're probably not going to know the answer. And I'm just, so you know, I'm an engineer, ran a software company, I wrote software. I know as engineers too, if I looked, I might spend 3 or 4 months solving a problem. And then when I see the problem solved, I'm like, oh, I know how to do that. So it becomes obvious to me, which is not the standard. So a lot of times we are, our own mental barriers of our own knowledge makes it tricky to figure out whether something's patentable. So what are the requirements for any technology? It could be mechanical, electronic, life sciences, healthcare, bio, games, anything. Useful, novel, and not obvious. Useful, it has some utility functionality. That's pretty easy to determine. So it's really 2, new and not obvious. New is pretty easy too, in the sense that, you can't scour the whole earth for everything, but you kind of know if this exists or not, right? So is anyone else doing this? And is it in an academic paper, a patent, or a product? And usually you have a pretty good sense of that because you're usually building a new product or service because it hasn't been done before. Or it has been done before and you're doing it in a new way that hasn't been done before. The tricky part kind of goes to that not obvious inventive stuff approach. And that's where the standard is if you can take 2 or more pieces of prior art product service that's published, and would it take really no inventive effort, creative effort, and you just put them together and you get there. And that's strategy, because the answer to that question is not always easy, what's obvious and not obvious. And as engineers, we can't use hindsight, right? That's a tech, like you're not supposed to use hindsight at all. But if, again, as an engineer, show another engineer what I did, they understand it. Hindsight, they say, oh, that's obvious. That's not the case. Because why, if it was so obvious, why did you spend 2, 3 months trying to fix it and solve it? Because you actually didn't know how to do it then, right? So we can't apply hindsight. And we'll talk about an application stack, right? And every prior art, every invention is made of prior art. So a lot of people say, well, I'm using open source and all these tools. True. Every invention is made up of building blocks of things that exist in the past. And again, I'll use software as another accessible example. Let's take a technology software stack. I have a web server, known. Operating system, known. I go grab a whole bunch of all the open source projects in the world that are meaningful to me. I put it in the stack, known. Any tools, Microsoft, whatever, Azure, backend, cloud services. So now I have the stack. It's sitting there. Most of the time, that existing stack doesn't do what you want to do, right? Because now this is where you're going to innovate. On top of that, you're going to add some value to that because the stack doesn't do what you need it to do, and this is where you're adding your value. So now go to the next slide. This is where I have people focus on their patentability, right? Your white space of things that are innovative is after you take everything that's known and it still doesn't do what your product or service needs to do, you've built value on top of that. And that's where the new functionality is on top of that stack. And that's where we look for patentability and innovation. And for you, you should say, is this new? Is it a competitive differentiator, right? This is a different kind of lens because it would become a candidate to consider for patent protection. So new, do you know of any competitors with those features or any products, right? Because you're trying to compete in the marketplace. A lot of your first movers, first one to do this or do it like this. So that becomes a good candidate. And again, kind of another way to collapse the patentability, I mean, the trade secret versus patentability approach has strategic value, right? Meaning this is our core competency. This is something like if someone, I always use the emotional test. If someone else did it, I'd kind of be bothered, right? That they copied me, right? So, because it's something that adds value to your product, why people buy it. So people should be looking at, I always teach entrepreneurs and tech execs, not to ask a question whether it's patentable, right? Look at your white space. Is it new and a competitive differentiator? If so, then you should be maybe talking to someone like us about whether or not it's something I may patent protect. Next slide. Data. This is a new tagline I like to use, new form of IP currency. We think of protection of functionality, products, and services, right? But data, especially for AI and all these things, data ownership is becoming so much more important. And people tend to treat data as kind of a big blob. Like a lot of you, even when you're doing Facebook, Instagram, LinkedIn, probably not looking at the data terms, and I have to go look at themselves. But a lot of times we treat it as a blob, like, hey, a typical customer will say, I'm going to give you my data, and I just want you to use that data for me. And if I go away, I want you to stop using the data. And a lot of times that doesn't work, especially if you're an AI company, right? Because if I train my AI model with your data, it's hard to undo that once you go away, right? And then I might need to train my AI model, say I'm a multi-tenant SaaS platform with different customers' data so that I can give the output to multiple customers there. And you may be adding your own data, like you want to respect customers' input and say they own it, but you may need rights to it too, to do what you need to do to create new products and service, create an AI model. And then you may generate your own data from it, like a benchmark score and whatnot. So contractually, this is how we protect that, understanding having a data governance model and figuring out, you know, who owns what data we need a license, which data is ours. And the reason is that most of you will sell a product service that has a kind of, let's call it a first utility, a first function in terms of generating money, right? And you sell that product or service. And then you're going to learn stuff from your customers, either through data flow through that service, data you learn about your customers, data from your system. And that's like a second order of monetization that later on you'll figure out how to turn on products and services. So I tell people, think about their data governance model for their companies as well. Next. But before we go this, Levon asks, if I have been using a name for a while for the difference maker competition, but I have not trademarked it yet, do I still have some intellectual protection if there's any question later on after I trademark it? If I can say, look, I have been using this name, so a little bit, yeah, you have some common law trademark rights to it, but it's not going to be the same as having a registered trademark to it. So if you're the first one to use that trademark and you're not misappropriating, infringing anyone's other trademark rights, you do have some common law protection, but you'll have more rights if you register it. And a lot of times it may not make difference if you're protecting it, if you had it first. Like if it's a big company and they think you're misappropriating their trademark, or they'll get a cease and desist letter. Yeah, I can say I've been using it for a while, but they're still going to want you to stop. So having a good trademark strategy, a brand strategy is important in terms, a lot of times we'll do prior art searching and make sure we can clear the name. Because a lot of it, even if you have certain rights, being able to enforce those rights or negotiate those rights with larger entities may not work out as well as you think, just, because your rights aren't absolute. When you have a patent or pending patent, are you safe to not use an NDA in B2B discussions? Yes and no. Yes, in the terms of you're free to discuss, you're not going to lose any more patent rights or give your innovation to the public because you already had it on file. Now, whether or not you choose an NDA may be for another reason. NDAs are good for protecting public disclosure of innovations before you patent protected them, but once you patent protected them, then you don't have that issue anymore. But NDAs are good practice because you have other forms of IP, confidential information, things that, and also from a sales process point of view, it's also good to see if someone has any interest in speaking with you and now they're willing to sign a contract. So you may want to share other confidential information. That NDA is a typical good process. You may, we're in the sales process and we coach you on this when to use that, because you can't run up to every person you're about to speak to them and they know nothing about your company, say sign an NDA, because like, wait, I don't even know who you are. I mean, let's talk a little bit. But sometime in the process, you're going to want them to sign an NDA with a third party for other reasons besides patent protection. Fashion manufacturers have all said they don't sign NDAs. That's unusual to me, because they may want to protect their rights. So that's a unique situation. We'll have to figure that out, because that seems unusual to me that most entities know how to sign mutual NDAs, be interested in who they are and how they approach. Yeah, they're really, it does sound sketchy to me, but in any cases, we can talk you through that, right? And let's say you have to be practical, like as an entrepreneur, you never get to risk zero. You have to manage risks. And one is what you disclose, right? Now, if I'm going to a manufacturer, I'd go to a manufacturer that I trust, because if you give them their secret sauce of what this thing is and how you make it and do it, and they're not signing any contractual terms to protect you, yeah, I probably want to find another source, right? Otherwise, we got to figure out other ways to manage the risk. So I'm going to wrap up here. Basically, there's a couple other slides I'll bounce through. IP strategy should always have one, make an IP decision. It's okay not to take action because of money, right? But make that intention, like, hey, I have something to protect here, but I can't do this now, or I'm at least going to put contracts in place to doing that. Develop an IP strategy, look at a toolbox. And just so you know, IP never stops, because a lot of companies I see will say, hey, I go file one patent. And then they don't think about IP anymore because they think they checked the box off. They did for the moment, but think Google search bar. How many patents you think are on that thing? Tens of thousands. Why? They look at their product, companies who are sophisticated, look at their product roadmap on an ongoing basis. Your version 1.0 of your product, first mover, you protect that. Next generation, well, you're still first mover because you're the first one to add these features and enhancements. They look at improvements to it to patent protect. So always be thinking about IP as you go along. I think I'm gonna have you move a couple slides ahead, Chris, just so I can bounce a couple things. Let me see. Boom, boom, boom. Oh yeah, key ownership. Let's stay in there for a quick thing. Go up there. IP ownership. So when Chris and I work on deals from investors and maybe look at companies like yourself, the one thing we look at is to make sure all the IP is owned by the company, which means each employee and each contractor have signed a written agreement assigned to IP. And then I know Chris mentioned about the contractors. On my IP side, contractors, you can get a buddy yourself to do some work and who's not under a contract agreement. Let's say he gives you a contribution to your website or your product or service. If they didn't actually, work for hire concepts. If they never signed a written agreement, assign all rights, title, interest, and IP to you, they technically own the IP. You might have rights to the work product, but you don't have rights to the IP. So now you go do a deal, a couple of years later, and someone's saying, hey, you need a written assignment. You go back to that person and ask them, like, oh, yeah, $10 million valuation now. Yeah, I'll sign that IP to you, but I want something for it, right? So it's always easy to do up front and have that. So that's a big concept. Make sure all IP is in the company. Next slide. Joint IP is bad. I'll just say that. So make sure you own all your IP, come talk to us. But a lot of people solve these problems like, hey, we'll both own it. This company, that company. Be careful of that. That's not an easy solution because they have the same rights as you to go do whatever they want with that technology. Next slide. Important bar dates. This is important. So under patent law, there's some the most patent offices are willing to give you that monopoly, but you have to follow some rules. One rule is that you have to a timely file, meaning that if you put it into public use, most countries say you actually, or public disclosure, most countries will say that you give it to the prior art and can't patent it anymore. In the United States, they give you a 12-month grace period. So let's say today you went to a trade show, demoed your product. That would trigger a 12-month grace period for you to file. And outside the US, you probably wouldn't be able to file it. Now, what's a public disclosure date? Very fact specific. I gave a demo at a trade show in front of 1,000 people, not under NDA. Definitely a public disclosure. Talking to this is why you go to NDAs. You know, talking to someone, disclosing the details of it to them under NDA, not a public disclosure. And then everything in between. If you put into commerce or offer for sale or using a patent product by somebody not under NDA and they're using the product, even though they don't know the invention's being used, it's still a public disclosure because the US government or most patent offices say you get the benefit of the innovation and it's out there being used in commerce. So a lot of early startups sometimes miss these dates. We help you with that as well. But like sometimes things can wait, like forming a company, getting funded. But regardless of your state of your company, the patent office doesn't care if your company's formed, you have funded. If you disclose it, you got to follow these rules. And I'm going to stop there because we're at the top of the hour. I don't know if anyone else has any other questions.
I have like a bunch of questions, but just because of time, I think maybe
Well, how's this, Sandy? What we'll do for you, why don't you ask one that's maybe one more that's applicable to the group, and then you'll have my email address and follow up, and happy just to have a convo with you about the others.
Let me think about which one. Well, I saw somebody else had a question.
Going once, going twice, going 3 times. Wait,
Anything, Sandy?
Okay.
no, I don't think that's enough. It may not be enough, right? So next gen testing versus next gen material testing. Yeah, that's pretty close. Like one, you know, if they had a trademark on it and the fact that you use they use next gen testing, and let's say they had a trademark on it, we have to look at the position. You just having the word material would probably not be enough, or like especially if you're doing the same type of things. And the best brand names are not generic names. Like next gen material testing is like kind of just describes what you do a little bit, so it's not that unique. In some ways, that may be a reason that you are able to use it because no one else can trademark it. But if you're looking to differentiate yourself from a trademarkability, you know, that's like McDonald. I call myself McDonald's with an A. Like that's not going to fly. That's pretty close, right? So next gen material testing is very close to next gen testing, and that would not be a material difference under a trademark analysis. Now we don't know if they have a trademark, and we don't know if they're in the same business or not, and what their scope of protection is. But we'd have to look at that, right? So if I was out like trying to name my company, and I saw a bunch of names like that, I wouldn't do a one-word change like that. I'd probably try to come up with something more unique. And someone has a question related to my business. Abdullah, go ahead.
Hi, Chris. Thank you for your time here. I had a quick question about more related to my business. I don't know if it can be related to others, but our sort of idea is a gel that with a delivery system that will be implemented in electric vehicle battery packs to enhance safety. And so when there's an accident or overheating issue, the gel and delivery system will activate and cool down the battery pack to extinguish any fires related to lithium ion. And my sort of question is, we want to go and implement this as a regulatory standard. So we want to have maybe even beginning in the state level and then work our way to the federal level, have it so it's mandated to have our system integrated in new electric vehicle sales. I don't know if you have any advice on that, or if that's
Well, that's a big ask, I guess. I don't do regulatory, but I know being a former business owner doing that, that's a big big cup of glass to swallow there in terms of making that happen, because you need lobbyists, you need money to do that, right? You're trying to bake something in to make it a requirement that everyone has that. It sounds like, hey, great, if I do that, then people buy my product. Not so easy to do. It takes a lot of time and effort to do that. So I would pause on that as a strategy, unless you have lots of money in connections, because you have to find people there. And it would be a parallel path anyway to do that. I think, I don't know what stage of company you are and where you are, you know, maybe you proved it already and maybe get some adoption and some people want to use it. But I think, like say as an investor, if you said that, that would scare me, because like if that's a requirement for you to, you know, your company be successful, I probably wouldn't invest in it. I think as a vision someday, like, you know, a few years from now, you know, in terms of being successful and adopted, that'd be a great thing to have, but it does take a lot of lobbying time, effort, political pull, all kinds of stuff to make something, pull that something off.
I see.
So that'd be my first advice is make that like a second or third generation type of goal versus out of the box.
Yeah, we were thinking of starting in the state level. So states like California, I believe, would be quick to adopt something like this because they're always pushing towards
Well, yeah, no,
clean.
I would socialize it without a doubt. You could start doing that, but don't lead with that. Like, because again, investor, if like you're telling me, hey, once I get California adopt this, you can make a bunch of money. I'd be like, no, thanks. How's this? Or I'd say, wait until you get that to happen, and then I'll invest, right? Because I think you want to show viability that it works, people, and then you want to show, you know, manufacturers are willing to use it, right? Because if you think it's a good idea, but no manufacturers would ever adopt it or want to, because guess what? They have way more lobbying and dollars than you do to actually go and oppose you making that a requirement, right?
I
So
see.
there's a lot of stuff you have to work. It's not a bad idea to start socializing and get some kind of interest in that. But would I use that as my hedge pin for my success? Definitely not.
Gotcha. Okay. Thank you so much.
So Chris, I realize we're over the time.
Yeah.
If you have a few more minutes, that's excellent.
Yeah, have a couple of
Appreciate it.
minutes.
The only thing I want to mention to everybody is that they're offering 3 legal fee, I don't know if I want to, I'll say prize for lack of a better word.
Yeah, we have in-kind prizes where for the 3 winners, 3 selections from a difference maker competition, they'll have the opportunity to kind of engage us on in-kind service on a kind of pro bono basis up to a certain dollar amount. And we handle a lot of these kind of questions and concepts under there. And then any of you, just because I'm a UMass Lowell Riverhawk, if you want to have a follow-up discussion, I'm happy to find time in my schedule to have a call to go over some of these, no charge there as well. Because I know sometimes in this forum, you might have questions that are more particular to you and may not want to share here, and I appreciate that as well.
So, and the 3 prizes, those are the 3 offers of in-kind services. You have to do a write-up. It's in the document that I sent out. I just wanted to remind you of that in addition to the marketing document. And that'll be due in a couple of weeks after the last, the 4th session of our boot camp sessions. The first one was sort of the kickoff. That's not counted as part of the 4th. I believe it's June 26th.
Yeah.
So if there are any additional questions, I think
We can take one more question and then I would say.
There we go.
I got one question.
Follow up with me. Sandy, did you want to run one of your questions or you want to wait for a call?
Yeah, I just wanted to ask about the partnerships in IP. You had like mentioned it, but
What do you mean by partnerships? Like joint IP and partners?
yeah, well, so I have a meeting with somebody who is licensed. They've patented a universal zipper, and so I'm just kind of wondering like how I should navigate that, like if that's, I don't know, you just mentioned partnerships and IP, and I just
Yeah, when I say about joint IP, it's like, hey, when you're doing, right, you gotta be careful when you collaborate with folks, right, who owns it. So let's say you work with a vendor or someone else, a collaboration, a partner. And let's say you go in a room and you say, hey, I have this technology, it does A, B, and C. And they say, oh, can that technology do D and E? You say, yeah, I can. We're happy to do that. Well, they came up with the idea for D and E, right? Or if you said, hey, if we collaborate together, we're both going to own the collaboration IP jointly. Not good, right? Because if they own it jointly, you don't really have strong enough contractual terms. they're able to go and do what they want with their copy of it, right? So you want to be careful there. In this case, you're talking about licensing a technology. Think of it as someone else has a product or service that you want to license and incorporate in yours. That's more like it's less about, that's more of a, you're almost like a distributor or a reseller for them, or a partner in that sense. It's a little bit different, right? They're gonna have to give you license and rights for their products and use them in certain ways. There'll be a contractual term there. And it's really about the business terms that makes sense there. Because you're maybe taking a product or service from them, incorporating your product and service, you don't have, you're respecting their IP, and you get a licensed IP to put into your product or service. And you need the right to go market and sell. So it's usually in those cases more about the business terms, like how you're gonna make money together. Being respective IP, your IP is their IP, is your IP, their IP is their IP. You're gonna get a license or IP to use your product. They'll still own it, but you get a right to it. But happy to talk about any how to negotiate that a little bit further. I guess Joshua has one quick question before we log off. I'll take that, and that'll be the last one.
Yes, I wanted to ask you, thank you again for coming on. What does the ideal candidate to receive this award exhibit? Is it documentation for a preliminary patent? Is it an extensive patent search, being incorporated, having business partners, the progress and stages of the prototype? What are some key
Good question.
aspects of the
It
candidate
is
you look for?
multidimensional. I would say someone who can benefit from, I mean, you all can benefit from our legal services, right? But I think a readiness for it would be, like, I know some of you mentioned patent, doing a prior art search is not going to do it. It's like, do they have like a business plan, commercial ability that makes sense to come, use our services to kind of grow to the next level, right? So are they, it's really a readiness for our legal services based on multiple factors. Some of it is a gut, just from our experience, anecdotal, right? So there's not like a checkbox that we go through, but we're looking for someone who's ready and can use the legal service. Some people are too early for it. And some people are just in time, meaning, hey, I'm further along in the progress of my project or company that, yes, I have, the next step would be a natural step for me to start, getting access to some real legal services that help me move along. So it's not as formulaic. Yeah, it's a great question, right? And I think some of it is just based on, your story. So the coaching to you is tell us a story about how further along you're with the company, what you want to do with the company, why you need the legal services, and some of your strategy around that. And that's probably the best advice I can give you.
Excellent. Thank you very much.
A very appropriate answer. I like that.
Yes.
Thank you. Well, thank you very much, Chris and Chris.
Our pleasure. Go River Hawks, and great job, everyone. And hope I get to talk to some of you in the future.
And thank you so much for both your time. We really appreciate it. Your time, effort, and support and knowledge. It's really, really appreciated.
Right.
Have a wonderful day.
Happy to be here.
Awesome.
Thanks,
Thank you,
everyone.
everyone. Bye-bye.
Thank you. Take care.
Thank you again.
I'm going to stop the recording now and stick around for questions if anyone has any, and then we'll wrap up. And you can leave. You're free to go.
All right.